Jim Green. I'm an attorney and lobbyist on privacy and security issues from Mercury Strategies in Washington. And I sit here today in the distinguished and stylish shoes, trust me, they're beautiful, of Gail Slater of the Internet Association to introduce this panel. Unfortunately, she was called away, so it's my pleasure to introduce the panel called The Internet of Vulnerable Bodies, which will explore the legal, technical, and ethical dimensions of security and privacy risks associated with human bodies becoming connected to and reliant upon the Internet of Bodies. This panel will discuss the legal responsibility for unintended injuries resulting from the use of neuroprosthetics and touch on a larger constellation of ethical questions invoked by neuroprosthetics, including issues of autonomy, data security and privacy, just distribution, and management of public expectations. The moderator of our distinguished and internationally diverse panel will be Professor Andrea Matwyshyn of Northeastern University's School of Law in Boston, Massachusetts, USA, whose work focuses on technology and innovation policy, particularly information security, consumer privacy, and technology workforce pipeline policy. She is a former senior policy advisor and academic in residence at the US Federal Trade Commission. Our distinguished panelists include Professor Jennifer Chandler of the University of Ottawa School of Law in Canada, where she does research on legal and ethical issues related to emerging biomedical technologies. She's a co-author of an important article in last June's edition of Science magazine entitled Help, Hope, and Hype, Ethical Dimensions of Neuroprosthetics. Mr. Achim Klabunde, who heads the IT policy sector of the European Data Protection Supervisor. And finally, Ms. Judith Rauhofer, a lecturer in IT law at the University of Edinburgh School of Law and Associate Director of the Center for Studies of Intellectual Property and Technology Law, also known as SCRIPT. And with that introduction, I'll pass the baton to Professor Matwyshyn to conduct this very interesting panel.
Thank you, Jim, and thank you all of you in our audience, the brave souls who made it over to this venue. We appreciate your attendance and joining us in this conversation about the next generation of internet-connected devices and bodies. So let me start with a framing for a bit, and this is a topic near and dear to my heart because 2 years ago at the Privacy Law Scholars Conference in the US, I presented a paper called The Internet of Bodies. So I'm thrilled to see that it has been picked up as a policy term and that we have this whole conference talking about these important topics. So when we talk about the Internet of Bodies, the first question is, what do we mean as a matter of definition? What is the difference between an Internet of Bodies and an Internet of Things? Well, as Jim highlighted, the critical difference is partially that the Internet of Bodies refers to the situation where human bodies' functionality and integrity depends on and is coexistent with some internet-connected technology. And the way that I frame this in my work, which other framings are certainly possible, falls through 3 stages. So the first stage of the Internet of Bodies, or IOB, is the stage that we've already lived through and are quite comfortable with. The body-connected Fitbits, the monitoring devices that we wear on ourselves, whether it's an Apple Watch or it is a Google Glasses pair, or it is some type of physical tracking device on the outside of our bodies that collects information and shares it with third parties. But the second generation of these Internet of Bodies devices will be beneath the skin. They will be breaking the skin barrier and they will start to be progressively more internal. The first set of these devices we already have seen. Think of pacemakers with internet-connected elements. Think of cochlear implants that have Bluetooth connectivity. These are 2 of the case studies of early second-generation Internet of Bodies technologies. The third generation we haven't seen yet. They will be things like Elon Musk's neural lace, the situation where human bodies and external computers will be transmitting and exchanging, switching information back and forth in a theoretically seamless manner. So going back to the stage that we're in now, this second generation of the Internet of Bodies involves not only questions of privacy and security, but it also raises questions about the next generation of several subsidiary bodies of law. And I'll highlight some of these subsidiary bodies, and then we'll refocus on the privacy and security questions that our panelists will lead us through. The first of these subsidiary bodies of law involves intellectual property. What does it mean when we have patent-protected technologies that are embedded inside bodies and whose functionality causes the bodies to depend upon their continued accessibility? And what does it mean when, say, a software patent suit impacts a device that is implanted inside a human body? Let's take something like an embedded contact lens. So several companies, including Google and Sony, have been doing research and in some cases patenting injected contact lenses with internet connections that go straight into your eyeballs. So what does it mean when your eyeball is internet connected in a sustained basis? Well, obviously, as we'll discuss here, it means your eyeball is subject to the repurposing of that data stream and a third-party attacker potentially taking control of that technology that exists in your eyeball. So it leaves you physically vulnerable. But from a patent law standpoint, let's say that the software on your injected contact lens is deemed to be violating a pre-existing IP right. Who bears the costs of removing that lens? Does it just sit in your eye? Can the patent holder force you to remove the allegedly infringing technology? If they shut down the company that sold you the injected lens, does that mean that you are left with a dead device permanently injected into your eyeball? So there are these bodily integrity questions that will lead to new categories of harms that we have not previously seen in the Internet of Things. While the Internet of Things has certainly given rise to severe concerns with respect to data protection and security, we haven't seen physical injury in a way that courts have often been able to recognize as a cognizable injury for recourse purposes, at least in the United States. And we have, of course, a more permissive privacy regime than the EU does. So that's intellectual property law. And obviously, we have questions of end-user license agreements and what meaningful consent means in this context when consent refers to the continued functionality of some aspect of your body, as well as the data collection that comes with it. When the trusted partners who have access to your data stream are gaining the right to review the activity of the chip in your brain stem or your neuroprosthetic, suddenly the ability to monitor thought patterns raises questions about thought intrusion and physical engagement of humans with the formation of ideas in new ways that we haven't before seen. And so that has implications for deliberative process, both in terms of citizenship and in the United States, the First Amendment, and obviously there are dignitary concerns under EU law. So next, let's talk about bankruptcy and secured transactions and the financial services industry and the VC funding lifecycle. The way that we currently engage with startups is that we expect that a certain percentage will go into bankruptcy and that the key asset will be a database of information. And the protections that exist around databases in bankruptcy and in secured transactions, they don't necessarily provide the kind of robust protection that we might expect if the database is composed of, say, a live feed of information coming from your brain, or the live feed coming from your eyeballs of what you're seeing at that moment. Is it functionally an access right to the knowledge of what that human with that IOB device is seeing. Our law is not yet ready for this world that we are stepping into. And finally, we will face a host of regulatory issues. In the United States, some of these IOB technologies will fall in between the FDA and the FTC. And the types of devices that we have already discussed today, some of them will be medical devices, but for example, the lifestyle devices of, say, an injected augmented reality contact lens. That's not a medical device necessarily, and the FDA's current definition of medical device does not cleanly pull that kind of an IOB device within its scope. And the FDA has taken a hands-off approach traditionally in IoT and those first-generation IOB contexts where things like Fitbits, for example, have not been deemed to be medical devices. So extrapolating these existing regulatory frameworks will present challenges, and in particular, as many of you know, there are net neutrality battles going on in the United States. Well, if the thing that's connected to the internet is your pancreas, and that's already been approved by the FDA, and your pancreas needs a critical security update, and you have selected the wrong tier of service, or you are in a dead zone, what does that mean for the bodily integrity of people who have not received an equivalent tier of internet access? And we've all had that experience where, unfortunately, our phone has no service, right? It starts to present a new set of physical harms when it's your pancreas that has no service and it's not your phone. So with that, I will leave the comments. Obviously, the security and privacy concerns are tremendous when it is bodily integrity, and those data streams could be repurposed in ways that the human attached to them may not anticipate. And I will turn it over to Professor Chandler to take us through an example from the context of neuroprosthetics and deep brain stimulation.
Yes, that's working. Thank you, Andrea. Thanks also from me to all of you for being here. My topic is going to zero in on one particular class of prostheses, the neuroprostheses, and explore it from the angle of legal responsibility with some of these emerging applications, but drawing out how data security and data privacy are implicated in the kinds of puzzles that we're likely to see coming up in relation to responsibility. So just to situate this quickly, we have, I guess, three classes of technologies that are talking directly with the brain. And set aside psychotropic drugs and things like that, which talk with the brain chemically, but I'm looking here now at sort of electrical sort of communication directly with the brain. So brain-computer interfaces, neuroprosthetics, and then neuromodulation. The first two typically involve output coming out of the brain, signals coming out of the brain to interact with some aspect of the environment. And the third typically involves electrical input into the brain to alter some abnormally functioning or malfunctioning aspect of the brain's activity. So just very quickly, I couldn't resist putting up this slide with the picture of what has to be one of the first, I guess, BCI Christmas cards ever in the upper right for you. This is a holiday greeting from the discoverer of the EEG, electroencephalography, in 1924 to one of his friends, and you can see him imagining EEGing this card to his friends. But essentially what we're dealing with here is detecting the natural output of the central nervous system and then converting it in some way to output. This field has typically focused on neuroprostheses or different aspects of prostheses that are driven by brain-computer interface. Some of these replace lost function, so ways to actually bring input into the brain. In the case of sight and hearing, cochlear implant was mentioned, and then delivering outward the intents of the user to, for example, drive a wheelchair in the case of of paralysis. There are also investigations of prostheses for different aspects of cognitive function. So we hear discussions of artificial hippocampi for assisting with memory deficits. I want to move now, and I'm going to spend most of my time on neuromodulation, or the development of the techniques of deep brain stimulation. So just by way of setting up, we've had a very long human history of using electrical stimulation of the brain, including electric rays and eels in ancient medicine to deal with headache. More thousands of years of archaeological evidence of holes drilled in the brain to deal with various sort of, it's hypothesized, aberrant behaviors and things like that. And if we come forward a good couple millennia, we have deep brain stimulation, which takes over from ablative neurosurgery, which would go into the brain and destroy targeted pieces of tissue, for example, to deal with epilepsy, and is now employs electrodes delivered deep into the very specific locations in brain tissue to then deliver targeted stimulation. And it started out with movement disorders, Parkinson's, dystonias. It's gradually moving into a whole broader range, including psychiatric indications, anorexia, depression, addictions, schizophrenia, PTSD, and much more. So we're seeing this very, very rapid expansion of the applications or fields in which this is to be deployed. But in another way, we're also seeing dramatic changes in the nature of the technology itself. So the first sort of iteration or version of it was, I guess we can call open loop or conventional DBS. And this would involve the implantation of the electrode in the brain, and usually below the clavicle somewhere, a battery that would power this system. And the stimulation parameters, the strength of the stimulation, for example, the frequency, would be set by a doctor during sessions where the resolution of the symptoms would be observed until you got the right stimulation parameters. This was always on, or crudely, patients might have the ability to toggle between one or two states. But this is the way it has typically been done. It has several kind of downsides. One being that if you have something that's on all the time, you may not need the stimulation all the time, and you're draining your battery while it's uselessly on. Also, to the extent that there's side effects associated with this kind of treatment, you're going to get more of the side effects for nothing if it's always on. And so this has led to a lot of interest in this so-called closed loop DBS, which would involve the co-implantation of an additional electrode to detect the onset of a particular brain state that necessitates the delivery of stimulation, the DBS. This has also been done. We were talking about Fitbits and wearables. Another way of doing it, rather than a co-implanted stimulator or sensor, would be to have something on the hand to detect, for example, the onset of a tremor, and then the machine, through knowing its algorithm, could start to detect that sort of on the periphery, and then deliver the stimulation to head off the tremor. So this has been developed initially for epilepsy and is approved for epilepsy. So stimulation is triggered when the particular neural signature of the development of a seizure is detected, and then the stimulation is provided. Now, where we're moving beyond that is to user voluntary control of the DBS. This again would have a co-implanted electrode or set of electrodes, an array, that would then permit the user to have voluntary control over the stimulation by, in essence, engaging in particular mental tasks that the system could develop, which would be the essence asking the system, okay, now I want you to do X, deliver the stimulation to me. And the advantage of this, it said, is if you imagine yourself as someone with Parkinson's, one of the side effects of Parkinson's is you have the stimulation to deal with a movement problem, to deal with a tremor, for example, but the side effect of the stimulation is sometimes degradation of vocal output. So if you're up on a panel, for example, giving a speech, I might want to choose tremor in order to speak fluently. So you would allow someone to have that kind of sort of real-time control and trade-off amongst the side effects and symptom control. So this is where we are in terms of the evolution of this technology. Now, oops, let me move along here. here's where things start to get a little bit interesting, because we can see all sorts of potential issues emerging where we have people sort of either not in the loop anymore, if it's closed loop, some system is deciding when to stimulate their brain, or if they are in the loop, having some form of voluntary control over it. Now, the side effects of this kind of treatment depend upon where the electrodes are placed, and so would depend upon the nature of the condition for which the treatment is being provided. But we know that there's a not insignificant minority of Parkinson's patients who develop emotional and behavioral side effects, hypomania and mania. And I can't go, for reasons of time, through the details of these, but there have been at least one reported case of a criminal prosecution of a man whose stimulator was set up. He became hypomanic and ran down a street in Vancouver, in my country, in Canada, vandalizing cars, and when apprehended by the police was sort of euphoric, couldn't care less. He was clearly in a hypomanic state. And they turned off his stimulator. He became appropriately concerned about the prosecution. So we can see people starting to get into problems. There have also been a number of cases in Australia and Canada with these kind of symptoms developing into sexual offenses as well as drinking, gambling, drunk driving. So what are we going to do with all this in this kind of complex system where who exactly is in control of the stimulation? And we have a kind of a distributed responsibility. So I have for you a couple of legal cases. I'm just checking for if anyone's waving a 2-minute sign at me. Okay. So the first one, and I realized actually just now as I was about to launch into this, how I guess poorly chosen my example is I'm about to talk about motor vehicle accidents as if people are going to be driving their cars anymore. So just bear with me. Maybe we might substitute some other activity that might be dangerous, but I'm going to stick with that. So if we imagine someone who has been implanted with DBS, for example, for Parkinson's, and is in a motor vehicle accident, is in a car accident. And there's been a fair amount of ink spilled on, okay, well, who is responsible for this? Well, if the system malfunctions, if these become sort of networked, there's a data security problem, should the driver himself be responsible? And I think the law would say that you may not be responsible in the moment for something if you're incapable. You may well be responsible for the prior decision to use a system that you cannot control. So it's a species of negligence liability, which is very commonly applied to people who don't take their medication, have a seizure while driving, or fall asleep while driving, or any of these other incapacitating things that occur. The manufacturer responsible for design, production, marketing will be responsible as well. And here's where I want to talk a little bit about privacy issue, because this is a little bit interesting. So if this person had a voluntarily controlled DBS and for some reason decided they wanted to be able to speak to someone in the car, so downgraded their Parkinsonian symptom control to be able to say something, the accident happened, should manufacturers have an obligation to record the nature of the signaling and communications and the design in the system itself? And it seems this would be a wise thing to do for a quality control purpose, but it also acquires legal importance. Because if you were able to find out through this that the person sent the signal to switch off the stimulator shortly before the accident, you'd have some interesting evidence from the legal liability perspective. But notice the kind of perhaps unfairness of this. Anybody else driving around doesn't have a black box recording of what they were thinking and has deniability. But the person with the implant might have this record. So what are the responsibilities in terms of recording this? Should this kind of information be kept in the black box indefinitely? Should it be kept for limited periods of time? Should it only be kept if there's an accident? And so on. These might be questions to sort out. Second case, what about situations where the stimulation itself erodes capacity? The kinds of hypomania cases and mania cases I told you about. What if our driver develops this side effect? And here I wonder, I've beginning to wonder another interesting thing. Should this kind of system be, as sort of a design obligation, be detecting the onset of these behavioral disturbances, of the side effects, emotional side effects. And you can see at the bottom references to people looking at psychologically adapted brain-computer interfaces that can detect emotional states and then modify output or input as a function of these emotional states. Now this gets very complicated, of course, but people are working on it. One can imagine a situation where you might have some form of ignition interlock if someone's emotional state gets too far off the charts. And how is this algorithm going to work? All these, of course, provide sort of liberty, autonomy questions, as well as security questions, obviously. As a third case, and this is an interesting one too, since we're talking about things which actually deliver stimulatory input into the brain in the context of maybe treating mental illness, and you can see at the bottom people looking at how to do targeted stimulation to head off auditory hallucination in schizophrenia. So there's a lot of looking at this. How can we change the nature of mental phenomena where we have determined that certain mental phenomena are pathological and this is meant therapeutically? But as the broader principle, if we're able to start manipulating sort of mental contents and events, what does this mean for agency, namely the ability to make and act on choices? And a very interesting paper I read just in Frontiers in Neuroscience, published late this past year, 2017, I recommend to you as a data security-oriented take on this. Citation is there. Gladden says, you know, our typical approach to information security, looking at confidentiality, integrity, availability, is not going to capture the kinds of issues about agency-altering technology, whether it's we have our own control over it or not, closed loop or voluntarily modulated. And he says we should actually have a design obligation that allows people to distinguish and reject mental phenomena that come into their mind. I wonder how this might be done, and especially thinking in the context of auditory hallucinations where there's difficulty about knowing which are the real, which are the false, and philosophically, is an auditory hallucination to be understood as false, or is it a real aspect of experience? So there's a lot of philosophical as well as practical puzzles to sort out here. But for our purposes, the information security perspective, the interesting thing is, what do we do to preserve autonomy, and also as a matter of preserving people, for example, against hacks or compromises of the system, to allow them to know when the system is modulating their mental experience so that they can know when this is happening and sort of autonomously decide whether to go with a particular mental experience or not. And then finally, and more into the realm that I think about more, which in the criminal law and the brain and the mind, a set of other rather interesting responsibility issues pop up in relation to patient selection. So the citation to the right there, a group of researchers saying, since we know that a side effect of DBS for Parkinson's is impulse control problems, including hypersexuality, what do you do if you have a patient who has a problematic and potentially criminally risky set of sexual interests, such as pedophilia? Is it ethical to treat such a person? What forms of surveillance would one need to apply to make sure that nothing's going wrong? And then at the bottom, a friend of mine wrote about deep brain stimulation to reduce sexual drive. And we already in Canada and many parts of the world apply anti-libidinal drugs to control sexual interests. What does one do if this becomes possible as an alternative, say where pharmacological approaches are contraindicated for some reason? And would this be a system where you would not provide the patient voluntarily controlled form of DBS, but only the closed loop form of DBS? And what do we think about moving into that kind of world? And what are the various privacy and security implications of using them by way of some form of social security control as well? So I will stop there and turn it over. Thank you.
Thank you very much for the thought-provoking case studies, and I will now turn the floor over to Professor Rauhofer for some legal analysis from an EU perspective, and I think it's on.
it's on. Oh, wonderful. Sorry, I'm already sort of stumbling on the first hurdle. Thank you very much. Hello. I'm here to talk about the data protection risks and potential implications of this kind of technology. And that talk already is giving me lots of, sorry, I was sort of scribbling away because I had a skeleton sort of thing, and now I'm bringing all of this in as well. I gave a talk about the Internet of Bodies, what could possibly go wrong in a workshop a few weeks ago, and I think I did two things there that people kind of responded to, so I'm going to repeat them here. Andrea asked me to do a bit of a juxtaposition of the US and the EU position. I think one of the two things that I've always found when she started talking about the Internet of Bodies was that she said the Internet of Bodies is like the Internet of Things, and I think that's true. But what it actually is, it's like the Internet of Things with a Halloween costume, I think. So it's the whole idea of it, just a little bit scarier because of the potential implications for actual bodies, for actually minds, for actual people. And that's going to be interesting. That's going to be interesting from a liability point of view, and that is interesting from a data protection point of view, because liability and damage and how to calculate it, this has historically been a problem that we've been facing. But it's interesting from a number of other areas as well. The second sort of comparison that I tried to make is that from a data protection point of view, for me, the interesting thing is the distinction between that type of technology and what it could mean for the individual themselves. So the workshop where I gave this paper in the first time was called Everyday Cyborg, and when we talk about the everyday cyborg, the artificially enhanced human, we're thinking of something like the Terminator. So we see this one individual that actually has enhanced capabilities through technology. But what I'm actually worried about from a data protection point of view is not the cyborg, but the Borg. And that means, a host, an army of technologically enhanced individuals that are connected to some sort of a collective mind, a collective hive mind to a certain extent. And of course, the implications that could have, not just for the individual themselves, which is something that we're very, very quickly looking at, but for all the other things, the autonomy of that individual, but the societal and the collective implication that it could have on all of these individuals. So to put this into a data privacy context, I think, and everything I say about the US came out of a conversation we had, so I'm blaming her entirely. So from a US point of view, I suppose, how are we going to justify the data collection that's inevitably going to come out of the use of these technologies? Because one of the things that they all have in common, like the Internet of Things, is that they are mediated technologies. So this is not just stuff that happens with us, in ourselves. This is stuff where all the data that is going to be created goes out to somebody else. That's a well-known problem. We don't really, this is nothing new under the sun sort of stuff. In the US, this is relatively easy, I suppose. We're going to collect this data on the basis of blanket consents, and then the third-party doctrine, unless it is fundamentally revised, is going to do the rest, which basically means once the data is out there and shared with one person, it's probably going to be shared with a host of other people in many, many different ways for many, many different purposes. Potentially, unless we look at regulatory solutions in a relatively wide way of purposes and things to do. An interesting question there, which Andrea alerted me to, is whether or not this data is going to be called, or is going to be considered medical data, health data, biometric data. Because if it isn't, then some of the protections that exist in the US under HIPAA are probably not going to apply, and it's just going to be looked at as very bog standard normal data. So this is an interesting one, because we then look together at the definition of biometric data under the GDPR, and actually, it's a little bit iffy. On the one hand, you can say, yeah, it's data about potentially, physiological processes and behaviors and that sort of stuff, but is it really sufficient and sufficiently specific to identify one unique individual, which is what it would have to be under the EU definition? So that's quite an interesting question, because that also means, sort of addresses the question whether it's going to be considered sensitive personal data, and that again has an implication for how the EU sees it, albeit not as much as we might otherwise think. So that's one of the things to think about. So I think what we're probably going to be ending up with in a US context is some sort of relatively indiscriminate collection, use, sharing, and reuse for probably unforeseen purposes at this point of time of data that, whether it is deemed sensitive or biometric is still going to be highly sensitive, and intimate personal data with potentially predictable consequences for existing power balances that we have. Now, in the EU, the picture I don't think is quite as bleak, but it's not as if we've squared this particular circle either, because I think the GDPR has a number of loopholes built in that we are going to explore over the next 5 or 10 years, I would say. And we are asking some of the same questions. So I think the first question is, as in the US, is this actually personal data? Is it sensitive personal data? And that's one thing that we're going to have to figure out in this context. And I suppose, as with everything, to what extent can we make this? To what extent is it useful to make this data identifiable? To what extent is it completely unuseful, which means that the medical establishment will likely try and do everything to de-identify it, and is actually going to have the opposite fight of how do we keep it anonymized, how do we avoid Ohm's famous database in the sky, and all of that sort of stuff. So that's the first issue. In the EU, of course, we have a different type of authorizing use. So we have this prohibitive system where we can actually only collect that kind of data on the basis of a legal ground. So what's going to be our legal ground? I mean, I suppose consent in the first instance, because we are going to want to have these things done, because in many ways they are potentially life-saving, or at least quality of life-enhancing technologies, or sometimes even just fun technologies like the video game enhancing eyeballs and all of that sort of stuff. And we know from Internet of Things and even previous uses of technology that we as humans are all too willing to consent to data uses in exchange for something that we want more. So I suppose from that point of view, that's going to be consent is going to be a big one. But actually in some other cases we have the vital interest ground, or we have the substantial public interest ground, and that's going to be an interesting one, I think, going forward with regard to the data that is then shared collectively, so to speak. So I think we will not want for a legal ground to actually get this data come into existence and actually be able to use it for some reason. And of course the first reason, or the first purpose we're going to use it for, is actually in fact the original purpose. But the problem, I think, arises, as with all Internet of Things kind of data, with the secondary purposes for which that data might be used. And this is also where the majority of the data privacy concerns arise, I suppose. In the EU, we have a slight safeguard in the data minimization principle. So we will not necessarily be able to just go out there and collect everything under the sun and look what we can do with it later on. So that's one thing that we can look at. We then should also have the purpose limitation principle as a safeguard, so that if I if I consent to this data being collected for the purpose of my own medical care, then really my expectation, my reasonable expectation of privacy in US parlance would be, or should be, that it is not used for anything else. But of course, one of the things in the GDPR that we really all need to very much look out for is that research exception to the purpose limitation principle, because this is going to be a big one. For those of you who do not know this, the purpose limitation principle applies, so that basically means that the data will not be able to be used for anything other than the original purpose unless it is compatible with that original purpose. And this compatibility test is a pretty big test. But there is a giant gap in that particular test, where it basically says in the GDPR that further use for research purposes, among other uses, will always be considered compatible. And recital 50 of the GDPR then adds to that where that is the case, we no longer need a new legal ground for that new use for research purposes. So that basically means that we can collect this kind of data for any purpose whatsoever, on any legal ground whatsoever, and it is then almost free game for research afterwards. And what I can see happening here is that we make this kind of data available to the research community for very, very good and often probably public interest purposes. And this is, I always say that research, to this medical research in a way, will become, I think, the new child sexual abuse image argument, okay? We have always managed to get restrictions on privacy on the basis that we can fight child sexual abuse. And I think medical research is the opposite side of this. It's the if it's going to be doing good for the collective, if we can use it for research, and if we can fight cancer with it. That's the other side of thing. You know, it's so difficult to argue with that argument. So once we are in that situation, I think the problem that we were then going to have is that the medical community or the research community, in using this data and innovating, might actually find things that we could use it for. Okay, it might come up with these ideas of, you know, how do we then deal with these people going hypersexual, or these people maybe, you know, developing homicidal tendencies or something like that. And then all of a sudden, we have future uses that actually have directly come out of the research with the data, where we can then go back, speak to the legislator and can say to the legislator, could you now give us a legal requirement that we can use the data for that purpose? And we could actually have a really wonderful complete purpose loop in this context to sort of get further uses of that data established and justified and authorized in society. And I think that is something that, at least on an intellectual level, on a theoretical level, under the current framework or under the soon to be coming into force framework, is something that I can entirely envisage happening. What we haven't really done an awful lot is to think about what this will mean, not just for us as individuals, but I think also for the collective, for society as a whole. And I suppose this is one of the things that I'm, as a researcher, I'm always particularly interested in, the sort of the risks, harms, and power aspects of this whole thing, because the risks that we are looking at, in particular in context of data privacy and data protection, they are always so intangible, and we as humans are so incredibly badly suited to evaluate anything that isn't a short-term risk or an out-of-the-ordinary kind of risk, and we are so bad with envisaging this and really thinking about what's the worst that can happen. And the same way as humans with regard to harm, we're focusing on tangible over intangible harms. We're looking at individual harms over collective harms. We're looking at material harms over conceptually philosophical harms. And that is something, I think, with regard to big data, to the IoT, and now the IOB, we really need to look at, because that Borg scenario, I think, is there to a certain extent. So what I would probably want to do as a researcher looking at all of this, I would like to look at this as a philosophical concept. So not just what will this cost me as an individual or us in terms of money or loss of opportunity, but how will this affect individual rights in terms of autonomy, in terms of self-determination? To what extent can this data then be used against me as an individual to limit, to restrict my life, my behavior? And I was very interested in this whole, can we then potentially deny this kind of treatment to somebody who is at risk of, having certain side effects? I mean, to what extent does that then pitch individual autonomy against safety concerns of society? And to what extent does this allow us to discriminate, to stigmatize, to manipulate, to categorize? And that these are all concerns that we're already having, but not in very many other ways. And the other questions then, more societal, how will this change the power relationships, between the different actors in society? So who are we giving more power to, and who are we taking power away from? And I can see, again, the research community, the medical community, and all of these stakeholders increase in power very significantly. And that might, as we have seen with all other stuff, ultimately affect democratic structures. Because if power concentrates in certain areas, even in the private sector, as we are now seeing that private sector has an increasing amount of leverage, even with regard to regulation and what can and cannot be done, and that may ultimately again have impact on individuals and society. So that's sort of my slightly apocalyptic look at this whole thing.
Thank you very much, Professor Rauhofer. And I turn it over now to Achim Klabunde for a comment from a regulator's perspective and a regulatory framework for the coming Internet of Bodies.
Yeah, thank you very much, Andrea. Thank you also for this introduction, and maybe also thank you for inviting me to be on the panel, which actually has the same name as the entire conference. So I think that's a particular honor and pleasure. As you rightly say, I'm not a researcher, not working as a regulator, dealing with data protection, and also in particular as a computer scientist from a technical perspective. And So Judith just gave a nice analysis of all the issues that might be investigated more deeply and researched from a legal perspective. Obviously, in practice, we wouldn't have that capacity to do all this research, so we have to more decide on a case-by-case basis. And thinking of, and I'm trying to structure this a bit as maybe some other engineers would do it as well, to go from the general to the more specific and so on, but also from real-life cases. So when I think of medical ethics and medical devices and privacy, there's two things. One thing on the question of medical ethics was in the news this morning that Chinese researchers managed to clone a monkey, a primate, and that was considered a breakthrough. And while the Chinese said, well, this is good because it improves the medical means that we have, we can do better research because we then may have thousands of monkeys who genetically are all identical, so we can really distinguish the effects of a new drug, because that would be the drug and not the fine differences in the genome of the monkeys. European researchers and ethicists immediately came up and said, well, okay, so we are one step closer to cloning humans and we shouldn't go any step further, we should stop here. So there is, what I want to point out with this is that there is a cultural difference in ethical perceptions, which is reflected in many things, and which we also should will come to at some point when we, even if we all on this panel agree on certain ethical, not legal constraints, we may find that if we would have this panel on the other side of the planet, we would come to a completely different conclusion. And that, again, is something that we must take into account when we think where we should analyze matters from an ethical perspective. Okay, from a technical angle, when we talk of the Internet of Bodies, which is a term which, as Andrea well pointed out, is derived from the Internet of Things. So the engineering aspects, so all problems that apply to the Internet of Things also apply to the Internet of Bodies. And that is, when I have slides and talk about the Internet of Things, I have one slide which says the S in IoT stands for security. And then people look at the slide and try to find the S. And the European Commission in its recent package on cyber security expressed it a bit more politely. It said security concerns are not always a design priority in the production of Internet of Things devices, which is basically more politically correct speech, but indicating the same problem. So I appreciate that for medical devices, one expects that more care is given to security issues. But one expects, and not all expectations are always fulfilled. If we think of pacemakers, cardiac pacemakers, for decades the main concern with these pacemakers was that the different detection devices that we pass at airport gates could have a disturbing effect on the rhythm, could reset it, change the rhythm, and so on. So there's already, that was basically an unintended side effect of electrical fields, while now the concern is more that the pacemaker could be hacked by someone who actually wants to change it. Jennifer mentioned the malicious intervention. From a privacy perspective, there was a case last year where a police force in the United States wanted to use pacemaker data in a case of suspected arson, where the person whose house burned down was suspected of having produced the fire himself, and the prosecutor wanted to use the data from the pacemaker to follow because it was an adaptive pacemaker, so which would have reacted to body reaction, that if this guy was moving very quickly before the fire burned, that was probably why he was preparing the arson case. I must admit that I have not seen any reports on the final outcome of the case, but it was heavily discussed in media. So here we have one element where direct data from medical devices giving a totally new invasion into privacy. And that is, well, basically the first of the second generation of neuroprosthetic devices. I mean, cochlear implants could theoretically reproduce every sound that the bearer of the implant has heard on the day. So all conversations to which the bearer of a cochlear implant is witness could be extracted from some storage if they were there. So here I can say, okay, of course we can have legal constraints, but as an engineer we can avoid that by simply not having any storage in the cochlear device and no transmission of the sound waves which are translated into the electrical impulses to work on the auditory nerve. If it's not recorded, there's no way to reproduce it. But I mean, some engineer might just find it brilliant because the storage gets smaller and smaller, and it's so good you just can record 24 hours. So why shouldn't you do that? It could be helpful for something later. Well, and of course under European law it would be difficult to compile that. And I think we are also talking here in a way about a third generation of devices which are more than adaptive, which could, and I mean that came immediately up in the cases that Jennifer presented on mood changing things, and where actually the device has, the brain stimulation device has an impact which is not only in the interest of the individual concerned, but is actually a social interest being imposed on the individual. When I say this guy can easily become so aggressive that he is a danger for everybody around him, or a sexual predator or something, and when I have this device which issues deep brain stimulation when this condition approaches, then it's of course protecting the individual concerned, but also everybody around him who might benefit from this guy not becoming an amok shooter or something under these circumstances. So, but is it safe to leave that, I'm speculating, is it safe to leave that to the intelligence that is built into the device? Or should we maybe have supervision on this? So should we collect some data and have a control center which says, oh gosh, this guy is becoming dangerous, and there's a human looking at it and said, yeah, we get him the impulse to calm him down. So then we get closer to what Judith called the Borgs, or the hive mind, where that's of course a point. So, and well, I mean, I was in computer science since more than 40 years, and there has been talk about artificial intelligence all the time, and for the last 30 years, basically, we could always safely say, well, it's called artificial intelligence, but it's artificial, yes, but it's not intelligence. And over the last 10 years, we have seen tremendous progress, maybe not corresponding to the naive 1970s science fiction vision of artificial intelligence, but producing things which are difficult to distinguish from what comes out of a really intelligent behavior. And so even when I say that third-party controlled targeted deep brain stimulation may look like science fiction today, I don't feel confident to say that's not going to happen in my lifetime. And so I think it's something that we need to think about in the development. And I would like to get back to one more technical aspect, and also to illustrate an element of ethical concern, because we think of conflicts within ethical categories. So is it correct to give third-party control over the deep brain stimulation of this individual by balancing his autonomy versus some control? This is unethical. But Andrea mentioned the case that your device couldn't be updated to get the latest security patch to protect it against an existing malicious influence, because you were in an area without service, or your battery was low or something. But I mean, this is not a natural condition. I mean, the battery is low or there is no service because no one has invested in creating network coverage for the area where you were, or has saved on battery power on certain things. So we also have, and that is a very, I mean, then really the total health ethics debate explodes when you say it's a question of the resources that you invest. So, this deep brain stimulation device may cost, in each individual case, something like 250,000 to install it, or maybe even more, even though it may be less. But availability of this compared to other medical treatments just to stay in the same area, which benefit a much bigger number of individuals with much less resource-intensive devices, of course, somehow come to, at the social level, to the well-known question, can we afford to have more and more sophisticated medical devices for those who can pay, while at the other end we have very simply curable diseases where we just have people who cannot afford the most simple treatments. But okay, this is fairly out of the area of privacy and data protection. But when I think of our engineering demands, it's a standard practice for an engineer to have conflicting objectives. You want to have it available 100% of the time, safe, the best possible functionality, having control at the right places, and also to make sure that in the social field it is available where it is needed. So the one element of going forward is here that there really is the need to pay attention from the social political perspective. I'm very concerned about people who think investing billions in enhancing their own bodies is in kind of what's called transhumanist perspective is totally legitimate. I think there we need to see whether there's any way that this can be done in a way that is socially acceptable across the whole society. Thank you.
Thank you for those insightful comments. That is a perfect note to end on. I was going to ask a question following up on that last statement. What is the definition of a medical treatment versus an optional enhancement in this context? But I'll just put that idea out there and open it up in our last 10 minutes to the audience for questions.
I'll go up with the wireless.
Do we have any questions?
Thank you.
Thank you very much. Andrea Corti from the Technisches Bürgernetzwerk, Austria. And coming from to the invisible S in the IOB, I was wondering whether you're already generating scenarios for catastrophic failure that we in the cryptographic community see coming. All these devices, by necessity, cannot store, in most cases, significant amounts of energy, which means that they cannot use sophisticated cryptographic protocols. Now, there's a general consensus, which is reflected in the submissions to the NIST quantum-resistant cryptographic contest, that whatever happens, when we will have a quantum computer, and in case NIST is planning on 2025, the key length will be quite long. I don't think that most of these devices will be able to support the cryptographic protocols that will be needed to be resistant. So to us in the cryptographic community, a catastrophic failure is a very realistic scenario in terms of the data breach and information leakage of these devices. So I was wondering whether you have whether you are generating a privacy protection scenarios for a catastrophic event. Thank you.
That's a very good and interesting question, but I can only give a short answer. I'm afraid if this cryptographic catastrophe happens, the problems with these IOB devices will be a minor part of the large breakdown, because I don't see that the whole crypto world will be prepared in time with all the banking apps and financial things. That will be disastrous on a large scale. But I know that one of Europe's leading cryptographers will be at the conference tomorrow, so I'll ask Bart Preneel what he recommends.
So, Andrew Adams, Major University. Andrea already actually asked the question I'm interested in hearing people's viewpoints on, which is, at what point do we have a difference between enhancements and replacements? And what are the ethical and legal issues that's going to raise? I mean, the question has already come up in some of the earlier work on this, such as the cochlear implants. There's a big debate on that amongst the deaf community, and a big divide on whether it's appropriate to use cochlear implants early enough that they effectively become exactly the same neural developments as those born with a normal cochlear. So I'd like your feelings on that. What are the questions that's going to raise?
I think the distinction between therapy and enhancement's a really, really tricky one, and people talk about it in neuroethics a lot with the apparent expansion of cognitive enhancing drugs, so off-label use of stimulants like Ritalin and Adderall by students to study better and so forth. And of course we have these debates also in, in sport, doping and everything. I don't actually think it's very easy to distinguish between the two. I do think that it's a shifting baseline as far as what the standards of normalcy are in a society. I do think if I bring it, that's a long way to say I have no idea, but I can tell you that I think there's a legal implication that flows from this boundary, which is if you have a kind of a prosthetic that has certain risk attached to it, it's difficult to use, or it's poorly, sometimes intermittently difficult to control and so forth. I think that the kind of liability you'll have if you injure someone because it malfunctions will be a negligence style liability, and the judgment of whether you were reasonable to use the technology in any given circumstance, I think will be affected by whether it's perceived as palliating some sort of deficit versus just sort of some fun enhancement thing. And so anyway, there's a way in which I think it will have legal traction, and the courts will presumably tell us what counts as enhancement and what doesn't.
So following up on that, your case study of cochlear implants is, I think, a fascinating one. And in particular, one of the interesting aspects of, actually I'll highlight two interesting aspects of that case study. So the first is the nature of the technology itself. A cochlear implant does not produce an exact reproduction of the sound as experienced by a hearing ear. It instead creates a mechanical variant of that sound. So we are changing the human experience with the use of that technology. And some of these technologies, whether we characterize them as enhancements or as medical devices, will cause a different experienced reality of humanity. So that's a social question. The second social question is that in the cochlear implant scenario, it caused a rift in the deaf community about this very question. Is it an enhancement or is it a correction? And so if deafness is an identity, then it is a choice, perceived as a choice to step away from that defined identity in favor of a new one that's technology mediated. But if deafness is viewed as a correctable medical suboptimality in a human body, then it doesn't trigger these questions of identity and acceptance of difference in society. So it's a historically significant case study that is on point.
Yeah, and I think to add to that, I think the other thing that we can look at, and this isn't entirely, I suppose, on point, but one of the things that I'm always thinking about in terms of privacy is the extent to which us giving away our individual privacy can affect the collective. And I think one example that is maybe close to this, albeit not entirely on point, is the idea of tracking chips in children. If we were to come to a point where it has become ethically acceptable to choose to have your child tracked via a chip, on the basis of security, being able to know where they are, protecting them, we know all of the arguments for this one. This could start out as an elective procedure. But the effect this is going to have in a society is it's going to be having a conditioning effect. It's becoming normalized, and it's becoming normalized to the point where it's becoming mandated at some stage, not just by law potentially in order to avoid certain liabilities or in order to do certain things, but ethically. In the same way as it was perfectly normal that somebody like me at the age of 6 was able to spend the entire afternoon out of sight of my parents on a bicycle, and this day and age, if that happens, your parents are probably going to see social services very, very quickly if you got caught. So to what extent does the decision of an individual to give away their own privacy then affect other people's decision not to want to do this? And this can have impacts on, as I say, ethical ones, but it can also have impacts of what kind of procedures will we be required to undergo to keep medical insurance? What kind of procedures will we be required to undergo to remain free at large, rather than being under some sort of control? And I suppose this whole idea of this is my privacy, this is my decision, this is my elective enhancement can very quickly flip into something that you wanted to do this, now you have to do it, and everybody else has to. And I think that's one of the things where we have to have a real eye on the ethical implications and the legal ones as well.
We have time for one last quick.
One of the big points about the cochlear implant, anybody interested in this, I strongly recommend you read the cochlear implant debate. It's about the choice by parents for their children, because it makes a huge difference whether you have the implant at 18 months, which is the earliest you can have it, or maybe 2.5 years, or if you leave it later, when the child is maybe 7 and can make a personal choice, or even more so when they're a teen. It changes radically the effect of the implant if you have it done before the brain develops in a particular way. And I think we're going to see the same debate coming up in this area. First, it's going to be stuff for corrective, as in the cochlear implant, but then it's going to be, well, why don't you want to give your child cybernetic eyes, which can see much better, which have perfect vision, etc. And that's one thing we need to debate early on.
Or extra storage capacity in their brain so they can learn better in school.
Just imagine the middle-class parents.
Yes. So if there is one brief question, we have about 1 minute left. Yes.
Alessandro Dato from Tilburg University. From a legal point of view, I would like to know if you think that since we don't have any definition of brain data, do you think that we need a definition? Because even if we say that our sensitive data, I don't think that the principle of the GDPR, for example, are not even one is fit with this kind of technology, with brain-computer interface in particular.
Ouch. I'm not sure that the normal personal data definition wouldn't fit, because I think I'm not enough of a medic to be able to say just how identifiable their data can be, but I trust the medical community to not take too long to make it identifiable. So from that point of view, I think, and at least it might be, if it's not immediately identified, the way in which it is collected and stored might make it identifiable via third parties, via the combination of databases and stuff like that. The sensitive personal data is a different matter. And yes, I think at the moment we probably have a little bit of an issue in that the one leg of the definition, the whole idea of, does this record physiological processes and all of that sort of stuff is met. The other one, whether or not this can be related back to an individual and uniquely identifies a particular individual, may not yet entirely be met, but again, we may get there. So I don't know. I mean, I think it goes into the long list of questions that anybody who's asked any questions about the GDPR at the moment says, we'll just have the next 10 years to figure this one out, in the same way as we did with the directive, because we're looking at a completely brand new kind of scenario, both legally and technologically speaking. But I think the Article 29 Working Party's approach to identifiability as a singling out concept might gain traction at some point, in that we are no longer just looking at this as in, can this identify me as the person with that name living at that address with that identity number, but can this identify me as a persona, as an identity, as somebody who does something. And we're seeing this in the online environment, where even though I personally don't do social media under my own name, but I have an online persona. And that online persona is being marketed to, that online persona is targeted with certain things, that online persona is manipulated politically, and all of that sort of stuff. These are all things that they don't need my name for. So how is our idea of, identifiability and identity going to change? And I think the singling out approach, I would say, if we're in any way smart and wise, we're going to look at that in more detail, and that might actually come into play here as well. Does that help?
Just a short remark on the last part, the singling out approach. So the GDPR is absolutely clear that any type of identifier which boils down to an individual is sufficient. So if you cannot find name, address, birth date, whatever, but you can target the same person based on their IP address, it's identified. But the other point is on the initial question, brain data. It would probably fall under the definition of the GDPR of biometric data, because it's technically processed data from the body, which doesn't mean necessarily that it is a special category, what is often referred to as sensitive data, because that very much depends on the purpose and the information you can gather from that. When you can identify racial, ethnical, political, and so on, religious matters from this and health-related elements, then it is a special category data. But if it's just a stream of data from which you cannot draw any specific conclusions about these properties of the individual, it wouldn't pass the definition of special categories. Thank you.
And with that, we need to bring our panel to a close. I'd like to thank our panelists for sharing their insightful thoughts with us, and I thank the panel chair. And we are free for cocktail hour.